The banking sector, which now gets more ammunition to fight bad loans. The Parliament last evening passed the Bankruptcy Law to usher in time-bound insolvency process. According to the new law, the insolvency process can actually be wrapped up in just 180 days to preserve the economic value of the company. Minister of State for Finance, Jayant Sinha, said that this is a major step to clean up the financial system.
This was historic legislation, and it was very satisfying to find that there was consensus on this in the Lok Sabha and in the Rajya Sabha as well. This historic legislation will profoundly transform the Indian economy because it will make three very, very important things possible. The first is that we will be able to take assets that are dysfunctional, defunct, that are not being rejuvenated quickly, and enable those assets to be revived quickly or to be liquidated quickly so that the process of creative destruction can move faster, and that will really help the economy. So that's number one.
Right.
Number two is that we will protect important stakeholders in this, and these include workmen who will have up to 24 months of protection, as well as creditors who will find that their creditor rights are very significantly strengthened, and because their creditor rights are significantly strengthened, they can lend with a lot more conviction, and they can lend with lower rates because they know how the recovery proceedings will happen if bankruptcy is triggered. So that also is very important, that we are protecting these very important stakeholders in this fashion. Number three is that because the recovery process is going to work so much better, we think that it will stimulate the creation of a much deeper, more liquid corporate debt market because it's now possible to price what a recovery will look like, and because creditor rights are now very well clarified through the waterfall process that we've set up.
Right. So what about existing cases where there is willful default? For example, we have a case of Mr. Malia as well. So can the provisions of this code be also applied to existing cases?
Yes, absolutely. If creditors so desire, they can invoke bankruptcy proceedings in all existing cases, except for those that are obviously with appellate courts.
Right.
For example, the Supreme Court, obviously.
Right.
But for all other proceedings, it will be possible for us to be able to invoke this bankruptcy process and to put these assets into this resolution
Going
process.
by your experience as a banker, do you think there will be strong triggers enough for creditors or say for an employer to initiate bankruptcy proceedings? Are there provisions strong enough that will give the someone that trigger to initiate such proceedings?
Absolutely. The provisions are very strong. All stakeholders virtually have the ability to invoke bankruptcy. The workmen can do it, operational creditors can do it, financial creditors can do it. And once they invoke the bankruptcy process, then it's very well laid out and it's time-bound. So we think, in fact, that what we will see in this is that we'll see a lot of preemptive negotiations because this set of rights is available for creditors, for workmen, and so on.
All right, so that's the historic legislation that was passed by Rajya Sabha last night.